For now, you are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
For the record, my name is Thomas Styron II. It is not the name you have attached to this case. I believe that's a state created entity, Your Honor. Okay. And me being a living person. My name is in proper punctuation. I don't have a all caps name. So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Good morning. 14B District Court is now in session. This is Magistrate Hillary Braley presiding. Okay, and I need you unmuted at the jail. There we go. Can I have your name, please?
For the record, my name is Thomas Styron II. I'm the natural person. I'm the living man. How are we doing today, Miss Braley?
We are upright, if nothing else. So, okay. And you said your name is Thomas Styron.
The second.
The second.
And then I'm the natural person, the living man.
Okay, thank you for your patience there. We had a little bit of a kerfuffle. So, no problem. Recalling case number 19S00472, that is the state of Michigan versus Thomas Ulrich Styron, the second, you said, and also calling 24W001025, that is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. It is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. Okay. And me being a living person. My name is in proper punctuation. I don't have a all caps name nor.
Okay, I'm going to cut you off right there.
I don't have no contracts with the state of Michigan at all, period. And so I was wondering about personal jurisdiction and subject matter jurisdiction in regards to this.
Okay. And you can continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not. I don't even own a license. I canceled my license years ago.
Okay. So, what you are being charged with is operating a motor vehicle without having a license on your person. So, I'm not asking you if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused me of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I was traveling home.
Okay.
I wasn't doing business at all. And also from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir. But we are not going to get into that for now. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
At this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pre-trial for that entity? I don't. Yeah.
I hear you. And at this point, you are appearing in front of the court. You have put your name on the record. And yes, we are setting a pre-trial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have attached to that case.
And you can provide documentation of such at your pre-trial date, which is going to be June 26th.
So the documentation that I have published, recorded in excuse me, sorry. The documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case, that's, I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records, is that good enough?
Whatever documentation you have, bring it with you to your pre-trial date. That is what I am telling you, yes. So, and again, that court date, June 26th? Okay. Will be June 26th at 9 a.m. before Judge Washington. The court will enter that you are standing mute to all charges at this time.
So we're just assuming jurisdiction though, correct?
Yes.
How? From my understanding, that has to be proved before we even proceed with anything else. Am I wrong?
You are not correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay, so at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
So I need to be there under threat, duress, coercion of going to jail?
What we just witnessed is a textbook example of a jurisdiction challenge rooted in what's commonly associated with sovereign citizen-style arguments, where a defendant attempts to separate themselves from the legal name listed on the charging documents. Let's break this down carefully and professionally. First, the original charge: operating a motor vehicle without having a license on your person. Under Michigan law, as the magistrate clearly explains, that is a misdemeanor punishable by up to 93 days in jail, a $500 fine, court costs, or both. Notice something important here. She doesn't argue whether he had a valid license. The issue isn't ownership of a license. The issue is whether he was operating a motor vehicle and did not have the license physically in his possession when required. That's a statutory requirement in many states. Now, the defendant pivots quickly. Instead of addressing the factual basis of the charge, he questions personal jurisdiction and subject matter jurisdiction. These are real legal concepts, but they are often misunderstood. Subject matter jurisdiction refers to the court's authority to hear a type of case. A district court absolutely has authority over misdemeanor traffic offenses. That's not controversial. That's statutory law. Personal jurisdiction refers to the court's authority over the individual. In criminal cases, personal jurisdiction is typically established when an offense occurs within the geographic boundaries of the court's authority and the defendant is physically before the court, which he clearly is, appearing via jail Zoom. When the magistrate answers yes to jurisdiction, she isn't making a casual assumption. She's relying on statutory authority that already establishes it. Jurisdiction in this context does not need to be proven in the dramatic way the defendant suggests before scheduling a pretrial. It's inherent in the court's structure. Now let's talk about the name argument. The defendant repeatedly claims the name attached to the case, particularly in all caps, represents a state-created entity, not him as a living man. Courts across the United States have consistently rejected this theory. Capitalization of a name on court documents has no legal effect on identity. It does not create a separate corporate entity. It does not dissolve liability. It is simply formatting. The magistrate handles this strategically. She doesn't debate philosophy. She doesn't escalate emotionally. She simply says, bring whatever documentation you believe supports your position to the pretrial. That's actually the proper procedural move. The arraignment stage is not the place to litigate identity disputes. It's to inform the defendant of charges and schedule the next step. Another key moment. The court enters that he is standing mute. That's standard procedure when a defendant does not enter a plea. The court enters a not guilty plea on their behalf to preserve constitutional rights and move the case forward. It's not punitive, it's procedural. And here's the tension point when he says, "So we're just assuming jurisdiction, correct?" And the magistrate calmly replies, "Yes." That answer may sound abrupt, but legally it's grounded in statute. Courts do not need a mini-trial to prove they exist or that they have authority over crimes committed in their district. So what's really happening here? We're watching a clash between statutory criminal procedure and an individual asserting a personal interpretation of legal sovereignty. The court stays structured. The defendant stays persistent. But the system moves forward regardless. Now here's where it gets interesting for viewers. Do you think arguments about punctuation and identity should carry legal weight? Or do you believe courts must rely strictly on written statutory law to function consistently? Because at the end of the day, this case isn't about philosophy. It's about whether a motor vehicle was operated without a license on hand. That factual issue hasn't even been addressed yet. Everything we saw was procedural groundwork. The magistrate sets a personal recognizance bond, meaning he's released on his promise to appear. No cash bond. That's actually favorable. The court then schedules the pretrial before Judge Washington, where motions, documentation, and actual legal arguments can be presented properly. Professionally speaking, this hearing accomplished exactly what it was supposed to accomplish. The defendant was informed of the charge. Maximum penalties were explained. A future court date was set. Bond conditions were clarified. A plea posture was preserved. No theatrics changed the procedural outcome. This is an important lesson in courtroom dynamics. Courts operate on statutes, case law, and established procedure, not on individual interpretations of identity theory. Whether those theories are sincerely believed or strategically used, they consistently fail when tested against binding law. Now we'll have to see what happens at that pretrial. Will documentation be presented? Will motions to dismiss be filed? Or will this ultimately come down to the simple statutory question of compliance? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.